Hello friends. In this part, we shall discuss about two more special types of contracts, that is contract of bailment and contract of pledge. We shall discuss about what is a contract of bailment, what are legal rules related with the contract of bailment, rights and duties of both the parties, that is Bailor and Bailee. Then we shall discuss meaning of the contract of pledge, and then we will wind up this discussion by understanding the difference between contract of bailment and contract of pledge. So let's start with contract of bailment, its meaning and various legal rules related with contract of bailment. Section 148 of the Contract Act gives the meaning of contract of bailment. Section says that when a person delivers some goods to another person for some purposes with the understanding that goods shall be either returned to or disposed of according to the instruction of the person delivering those goods. This is called a contract of bailment. So, as per section 48, a bailment is delivery of goods by one person to another for some specific purposes under the contract that these goods, when the purpose is accomplished, shall be returned or otherwise disposed of according to the directions of the person who is delivering these goods. This is contract of bailment. Before analyzing various legal aspects related with the contract of bailment, it would be useful to have certain examples of these kind of contracts. When I send my TV to service center for repairing, I am entering into a contract of bailment. When somebody is delivering old jewelry to goldsmith for polishing purposes, this is also a contract of bailment. Handing over the goods to the transporter for transportation is a very common example of contract of bailment. Giving clothes for dry cleaning is another example of contract of bailment. Hiring of a taxi for tour purposes is also a contract of bailment. In all these cases, one party has delivered goods to another party with a specific purpose, and these goods are to be returned back when the purpose is complete. This is what makes all these contracts a contract of bailment. And to make our basic idea complete about the contract of bailment, let's understand two terminologies related with this type of contract, that is Bailor. Bailor is the person who is delivering the goods, and another is Bailee. Bailee is the person to whom goods are being delivered. Bailor and Bailee, these are two parties involved in a contract of bailment. After generating a basic concept of the contract of bailment, now let's discuss various legal rules related with the contract of bailment. Mainly, what are the duties, what are the rights of both the parties involved in the contract, that is Bailor and Bailee. The first rule is given by section 150, and it is regarding duty of the bailor for disclosure of faults in goods. Section says that the bailor is bound to disclose to the bailee faults in the goods bailed. However, section further clarifies which kind of faults are required to be disclosed. those faults of which bailor is aware and which either materially interfere with the use of goods by the bailee or which faults which may expose the bailee to some extraordinary risks. This is a duty of bailor to disclose all these kind of faults to the bailee. Now, what will happen if bailor fails to make this disclosure? Section further says, if the bailor does not make such disclosure, he shall be responsible for damages which are arising to the bailee directly from such faults. So, what is required by the Act is that bailor should disclose faults in the goods, else should bear the responsibility for losses. However, he is required to disclose only those faults which he himself is aware of. He is not responsible for such losses which were not in his knowledge. However, in case of a bailment for hire, the section puts an extra responsibility on the bailor regarding disclosure of faults. Section says, if goods are bailed for hire, the bailor shall be responsible for all kinds of damages in the goods, even if he was not aware about the existence of such faults in the goods bailed. So in case of a normal bailment, bailor is responsible for only such damages which were in his knowledge at the time of bailment. But then section says, if the bailment is for hire, the bailor is responsible for any type of fault in the goods, damages caused to the bailee due to any problem in the goods. Even if bailor was not aware about such faults in the goods bailed, he shall still be responsible in case the bailment is for hire. Say for example, Mr. A hires a taxi car from B. The car brake fails and A is injured. Though Mr. B was not aware about brake problems in the car, B shall be still responsible to A for this injury. Now let's see the contract of bailment from the angle of bailee. Bailee, the party to whom goods have been delivered. What shall happen in case the goods bailed have been lost, destructed or deteriorated? What kind of care a bailee is required to take of the goods bailed? Section 152 discuss this aspect of the contract of bailment. Section says, the bailee is not responsible for the loss, destruction or deterioration in the things bailed if he has taken that care of goods bailed to him as a man of ordinary prudence shall be taking care of his own goods. So if bailee has taken proper care of the goods, then he shall not be responsible for any loss, destruction, damage or deterioration of the things bailed. However, the contract of bailment may provide otherwise. If nothing has been provided in the contract of bailment, then this section 52 normal rule shall be applicable. Section 153 discusses a situation when bailee does something which is not consistent with the contract of bailment. Section says, a contract of bailment is voidable at the option of bailor if the bailee does any act with regards to the goods bailed, which act is inconsistent with the conditions of the bailment. Say for example, if the bailee puts the goods for some use not contemplated by the contract of bailment is voidable at the option of bailor. Bailor may, if he so decides, cancel this contract. For example, where Mr. A lets to B for hire a horse for his own riding, B uses this horse in a horse carriage. A at his option may terminate the contract of bailment in this case. Section 154 tells us about the liability of the bailee if he makes any unauthorized use of the goods bailed. According to the law, if the bailee makes any use of the goods bailed and this use is not according to the conditions of bailment, then the bailee shall be liable to compensate to the bailor for any damages which are arising to the goods from the unauthorized use or during this unauthorized use. Let's clarify this with an example. Mr. A gives a horse to B for his own riding. Now B allows C to ride this horse. Though C rides with full care, but still horse accidentally fails and gets injured. In this case, B is liable to make compensation to A for whatever injury which has been done by horse. This was an unauthorized use of horse, and accordingly, bailee shall be liable under section 154. Section 158 gives the rule related with repayment by the bailor of necessary expenses incurred by the bailee. This rule is applicable in a case of a gracious bailment, that is, where bailee is not to receive any remuneration. In such case, section says that when under the conditions of the bailment, the goods are to be kept or to be carried, or some work is required to be done upon these goods, and the bailment is gracious, the bailee is not to receive any remuneration for this work. It is the responsibility of the bailor to repay to the bailee whatever necessary expenses have been incurred by the bailee for the purpose of bailment. Section 159 talks about right of bailor to demand the goods back even before completion of time of bailment. This rule is applicable only in case of a gracious bailment where bailee is not to receive any remuneration. Section says that the bailor, in case of a gracious bailment, has a right to demand the goods back even before the expiry of period of bailment. The period of bailment is still there, but in case of a gracious bailment, bailor shall always have a right to demand the goods back at any time from the bailee. However, if in this process loss is caused to the bailee, the bailor is bound to compensate for this. Section 160 of the Act talks about duty of bailee regarding return of goods bailed on expiration of time or on accomplishment of purpose for which goods have been bailed. Section says that it is the duty of the bailee to return the goods or to deliver the goods according to the bailor's direction. The goods bailed without demand as soon as the time for which the bailment has been made is over, or the purpose for which the goods have been billed has been accomplished. The key point here is the duty of bailee is to return the goods without any demand by the bailer. The bailer is not required to make any demand. This is the duty of the bailee to return the goods as soon as the time is over or the purpose has been accomplished without waiting for the demand from bailer. And then section 161 gives us the provision regarding responsibility of the bailee when he has not returned the goods to the bailer. Section says, if due to the fault of the bailee, the goods are not returned back to the bailer or they have not been delivered as per the instructions of the bailer at the proper time, then the bailee shall be responsible to the bailer for any loss, destruction or deterioration of the goods from that time. Section 163 of the Act discusses a situation when there is an increase to the goods billed or bailee has derived a profit from the goods billed. Section says that in this situation, the bailee is bound to deliver to the bailer whatever increase or profit which may have accrued from the goods billed. Of course, parties may have a contract to the contrary, but if the contract of bailment is silent on this part, then bailee shall be responsible to deliver whatever increase, whatever profit which has been occurred, which has been accrued from the goods which have been billed. A very simple example may be, Mr. A leaves a cow in the custody of Mr. B to be taken care of. This is a contract of bailment. Then the cow has calf. B is bound to deliver the calf as well as cow to Mr. A. Section 164 discusses a situation of bailer's responsibility when the bailer was not entitled to either make the bailment or to receive back the goods. Section provides that the bailer is responsible to the bailee for any loss which bailee may sustain due to the reason that bailer was not entitled either to make the bailment or to receive back the goods or to give any directions with respect to the goods. The bailer has done any of this thing without being entitled to do so, and because of this, bailee has suffered any loss. The bailer shall be responsible to the bailee to make good these losses. Another legal rule related with the contract of bailment is given by section 166, which talks about responsibility of bailee when he returns the goods back to the bailer, but bailer has no title to the goods. Section says, if the bailer has no title to the goods, but bailee in good faith delivers them back to the bailer, the owner of the goods, the original owner, cannot have any claim against the bailee. The bailee shall not be responsible to the owner in respect of such delivery. The section basically absolves the bailee from the work done in good faith. After discussing various legal rules related with the contract of bailment, analyzing duties and rights of the bailer and bailee in different situations, let's have some discussion about a particular situation, that is finder of goods. If somebody finds goods belonging to others, what is his legal position? Section 168 discusses the right of finder of goods. The question which this section answers is that a finder of goods has to incur certain expenditure and has to take trouble to preserve the goods and to find out the owner. Whether he can file a court case for compensation in this respect. Section says that a finder of goods has no right to sue the owner for compensation for trouble taken and expenses voluntarily incurred by him to preserve the goods and to find out the owner. So law makes it very clear that finder of goods cannot take help of court to take any kind of compensation from the owner. So, if he cannot sue, how a finder of goods can enforce the compensation for all the trouble he has taken and the expenditure he has incurred? The section further provides and says that the finder of goods may retain the goods against the owner until he receives such compensation. So the situation is this: he cannot sue, he cannot file a court case, but he can always retain the goods against the owner until he receives compensation for his trouble, for his expenditure incurred. Section 168 further covers another situation, that is, when the owner has offered a specific reward, what shall be the situation of finder of goods with respect to this reward? Section says that where the owner has offered a specific reward for the return of goods lost, the finder may sue for such reward. For this reward, he may file a court case against the owner, and until he receives the reward, he may retain the goods with him. So in respect of any specific reward offered by the owner, the finder of goods may file a court case and may retain the goods until he receives this reward from the owner. Section 169 discusses another situation related with the finder of goods, that is, when he may sell these goods. Section says that when the thing which is of such a nature that it is commonly subject of a sale, and this thing has been lost, and then the owner cannot be found, cannot be traced with reasonable amount of efforts, or he refuses to pay the lawful charges of the finder, then the finder may sell these goods in two situations. One, when the thing is in danger of, say, getting perished, getting damaged, or losing the greater part of its value, or he may sell it when the lawful charges of the finder in the respect of things which have been found amount to at least 2/3 of its value. Now let's discuss another concept related with the contract of bailment, that is concept of lien, general and particular lien. Lien means a right to retain the goods. Section 170 talks about particular lien of bailee. Section says that where the bailee has, in accordance with the contract of bailment, in accordance with the purpose of the bailment, has rendered any services in respect of goods bailed, then he shall have a right to retain such goods until he receives due remuneration for the services he has rendered in respect of these goods. So until the bailee has been paid for, he may retain these goods. This is called bailee's particular lien under section 170. Say for example, Mr. A has delivered a rough diamond to Mr. B, who is a jeweler. This diamond has been delivered to be cut and polished. B has done it accordingly. Now B is entitled to retain the diamond till he is paid for the services which he has rendered to Mr. A. The point which needs to be considered, that a bailee may retain the goods only in respect of that contract for which these goods have been delivered to him. If he is to receive any other amount from the bailor, he cannot the goods which have been delivered to him under a different contract of bailment, because he only has a particular lien in the matter. As against the particular lien of a bailee, section 171 gives a concept of general lien of a banker. It says that a banker, in the absence of any contract to the contrary, may retain as a security any goods which have been billed to them, whether the bailment has been made against that specific loan or against any other loan. After discussing various aspects related with the contract of bailment, let's analyze another special type of contract, that is contract of pledge. Section 172 defines the contract of pledge and says that pledge is a bailment of goods as security for payment of a debt or performance of a promise. Say for example, A borrows rupees 200 from B and keeps his watch as security for the payment of debt. The bailment of watch is a pledge. So, pledge is also a type of bailment. We may call it a special type of contract of bailment. The idea behind this contract of bailment is to provide a security for the payment of a debt or performance of a promise. In the case of contract of pledge, the bailer of goods is called Pawnee and the bailee of the goods is called Pawnee. In case of contract of bailment, we have discussed the right of retention of goods so far as a bailee is concerned. Now section 173 talks about right of retainer of goods by a pawnee in a contract of pledge. Section says that pawnee may retain the goods pledged not only for the payments of debt or the performance of the promise, but he may also retain the goods in the respect of interest on the debt, as well as in respect of all necessary expenses incurred by him in respect of the possession of goods and for the preservation of goods which have been pledged to him. So in this case, pawnee right of retention of goods is fairly extended. He may retain the goods until the debt has been paid for or the consideration for performance has been given to him, but he may also retain the goods until the interest on the debt has been paid, and also any expenses incurred by him in respect of goods have been paid by the bailer by the pawner. However, section 174 of the Act provides a restriction on the right of retainer of the pawnee. Section says that the pawnee shall not have a right, in absence of a contract to that effect, to retain the goods pledged for any date or promise other than the date or promise for which they have been pledged. So section basically conveys the message that pawnee can retain the goods only in respect of that date or that promise for which goods have been pledged with him. He cannot retain the goods in respect of other dates, other promises. After the right of retention of goods, another right of pawnee has been prescribed by section 175, that is, right to recover any extraordinary expenditure incurred by the pawnee. The section says that the pawnee is entitled to receive from the pawner any extraordinary expenses incurred by him for the preservation of goods pledged with him. What is important to see here is only any extraordinary expenditure incurred by pawnee may be recovered from the pawner. Expenditure of routine nature incurred by the pawnee for preservation of goods cannot be recovered. What will happen when pawner makes a default in a payment of date. What is the right of Pawnee in such case? Section 176 deals with this situation and mentions that if the pawner makes a default in payment of date in respect of which the pledge has been made by the pawner, then the pawnee shall have two rights. He may sue the pawner and retain the goods pledged as a collateral security, or alternatively, he may sell the goods pledged after giving a reasonable notice of sale to the pawner. So these are two alternative rights available with the pawnee. He may file a court case and retain the goods as collateral security, or he may sell the goods which have been pledged to him. The only requirement is this: for selling the goods, he is required to give a reasonable notice of sale to the pawner. Where the goods have been sold by the pawnee to recover his debts, section further says that if proceeds of such sale are less than the amount due in respect of the date or in respect of promise, the pawner shall still be liable to pay the balance amount. And if these proceeds of sale are greater than the amount which is due, the pawnee shall pay the surplus to the pawner. And finally, let's do a comparative analysis between a contract of pledge and a contract of bailment. We have seen earlier that a contract of pledge is also a special type of contract of bailment. So what are the differences between these two types of contracts? The purpose of contract of pledge is to act as a security in respect of any date or in respect of any promise to perform, whereas the purpose of contract of bailment is something else like repair, safe custody, etc. In case of pledge, the pledgee, the pawnee, has a right to sell the goods pledged on default of pawner. In case of bailment, the bailee does not have any right to sell the goods. In case of pledge, the pledgee does not have a right to use the goods. The pawnee cannot use the goods for his own purposes in case of a contract of pledge, whereas in case of contract of bailment, the bailee can use the goods as per the terms of contract. And this is the end of our discussion regarding contract of bailment and contract of pledge. Thank you.